Hello, everyone. Waiting on a few minutes to give or a few seconds to give everybody the chance to join in. I want to welcome y'all today. My name is Cliff Davis. I'm a shareholder with Roberts, Markel, Weinberg, Butler, Haley. And today we're going to talk about association contracts a little bit. Hang on a sec. So some of the discussion points we're going to talk about is the use of a master services agreement, understanding, hopefully you'll get a better understanding of insurance and indemnity, and risk transfer. One of the terms you're going to see in this presentation, and a term we use a lot, is vendor. And what the vendor means is any kind of service provider that an association uses. It's a landscaper, a plumber, a painter, a lifeguard company, a patrol company. And your professional team that you should use when entering into these contracts can be the attorney's office, your CPA, your banker, your insurance broker. And one of the first things we're going to talk about is a master services contract. So really what we try to get our associations to use is a template that contains some kind of boilerplate basic language. And then we take the vendor's document and usually handle that in one of two ways. Sometimes I'll take one and just attach the vendor's proposed document as an exhibit to the template that I use, or sometimes pull out the provisions from the vendor's contract, typically things like the scope of the services, which is something that the board and the vendor agree on, and I'll maybe pull out those provisions and put them into the template, the master services agreement. And really what we are looking for is a master services agreement that uses language that we've reviewed and that covers things like the terms, the scope of work, obviously not the details. We won't know the details of that scope until we see what the board and the vendor have agreed on. Insurance requirement language, indemnity language, what happens if there's a default, and right of termination. And what we think this means is that the use of this master service agreement, it helps the association where there's one document that addresses all the relevant points that need to be addressed in the agreement. We get a lot of vendor agreements in front of us, and they're just not sufficient in the things that they address. And we want to see just a bigger scope of issues addressed in those agreements. And that's why we try to use a master services template. That's what we start with. So, and typically the things, the most important things we're looking at are insurance provisions, indemnity, and termination. I'm sure you've all been in those contracts where you find out that it's a little more difficult to terminate that than you thought. And we'll talk about that again some more later. So obviously the first thing you want in the contract is the start date and the term. We see a lot of agreements that don't really address these things head on, or they're not clear. And obviously you want to know clearly what is the start date, what is the term of the agreement, what happens at the end of that term. Or does it automatically renew for another, if you sign a year contract with a vendor, does it automatically renew for another year? Is it a renewal for a month to month? And, we want the association always to know what the term is, to know how they can get out of it at that term, and to not be bound by the successive terms with a difficult termination provision. And it's really important that be looked at. Obviously, if things go south with a vendor, the association wants to be able to get out of that contract. And what we're looking for is termination language with or without cause. And another thing that we see a lot is that an association will come to us and they say, we're having a problem with this vendor. And the first thing we say is, send us a copy of the contract. And then the association or the manager says, well, you know what, I don't have a signed copy. I've got a copy signed by the board, or I've got a copy that's signed only by the vendor. So it's really important for you managers out there to make sure that you have a signed contract with every vendor that's signed by both parties. It might be a good idea to maybe once a year at least to sit down, look at your associations you represent, put together a list of vendors, and then check your file to make sure that you have a copy of the contract signed by both that vendor and the association. There can be an issue if we can't produce a signed contract in some cases. And one thing that I ask my clients to do is, or encourage them to do, is send me a copy of the signed contract, and that way I can put it in our file. So, we know that it's somewhere that we've got a copy of that contract that's signed by both parties. Again, as I mentioned, one of the most important provisions is a right of termination. I am sure that you have all been there where things go bad with a vendor and the board decides, you know what, we just want to terminate the contract. And then you find out that it's not so easy to terminate that contract. We see a lot of contracts with vendors that might say, if you want to terminate us, first you have to send us a letter and say what's wrong, and then we've got 30 days to try to fix it. And then if we don't fix it, you've got 30 days to terminate or go to mediation or something. We generally recommend that your contracts have a termination with or without cause, preferably 30-day notice, maybe in some cases 60 days. And that way, when things go bad, you don't have to go through this tortured process where it becomes a dispute over whether or not there actually was cause or what exactly the circumstances were. You can just say, you know what, we just think we need to end this. We're going to send you this termination letter. And within 30 or 60 days, this contract's going to be terminated. And there's no back and forth about why or how or what. And obviously that doesn't stop those things from happening. If you can work it out with your vendor in that termination period, that's great. And you can withdraw the termination, you can sign a new contract or whatever needs to be done to take care of the issues. But you definitely don't want to be in the struggle to get out of a contract that you don't want to be in any longer. You always need to look at a contract if you've got a termination provision that's with cause to see what constitutes default. Does the vendor have a right to cure it? Is it something that can be cured? There's sometimes where it's just something that's not going to be able to be fixed. And if you find yourself stuck in one of these contracts where there's this procedure for curing, it's going to be a real headache to get out of that contract. Another thing that we like to look at and that we address in our master services agreement is the use of subcontractors. Generally, you don't want that to happen. You want the person you contracted with for their employees to be the ones doing the work. And if subcontractors are used, you want them to have that same type of insurance. Really is the important thing with subcontractors that you're requiring of the vendor. You want them to use people that have just as much insurance as they do, just as much as you're requiring for the vendor. We look at rights of assignment. Our typical language is that the contract cannot be assigned without the board's permission or authority or approval. And what we see in a lot of vendor contracts is, well, we can assign it at any time, to whoever we want to and when we want to. And we don't really like that. A lot of times or sometimes you'll sign with a vendor and you pick that vendor because you like those people or you know that they can do a good job. And you want to make sure that those are the people you're going to be working with. You don't want to sign a contract with someone and then 3 months later or 6 months later, they say, you know what, we're assigning this contract to this other entity. Good luck with them. So you really want to make sure that your contract says that the board has to approve any assignment of the contract. And if you're, certain types of contracts like a construction contract, payment may depend on when is that contract completed. Is it actual completion or is it substantial completion, which typically means you can, if you're building a clubhouse, you can use the facility for its intended purpose, but there are still some things left, but it's substantially complete. So if you've got a situation like that where it's possible that you can use the facility or use the splash pad or whatever it is, but they're not necessarily finished, you want to be sure to know that when do you have to make that final payment? Is it upon actual completion or substantial completion? And who determines what is actual completion or substantial completion? Obviously, we want that to be the board that determines that. And there's ways to address that in language. We may put language in there that substantially completed to the board's satisfaction, which cannot be withheld unreasonably. And that may create a fact issue that's something to argue about. But there's ways to address that. And it is just an issue that if you have the type of contract that could actually finish whatever it is you're trying to use before it's complete, finally complete, you want to make sure you're addressing that in the contract of who's going to make that determination and how that may affect how the contract is paid. We see a lot of contracts too that just say that the amount of this under this contract is $50,000, but it doesn't tell you how that's going to be paid. So obviously, you want the terms of payment to be in there, whether it's monthly or if it's a construction type contract, you're probably going to have to put some percentage down, and there may be progress payments. And if it's a construction contract, you may want some retainage, which is an amount you hold back until it is finally complete. And you satisfy yourself that there's no subcontractor liens or no other issues before you give that retainage payment to the vendor. You have to look at how, if you're doing progress payments, the contract needs to specify who's going to approve that work and what is the mechanism if there's a dispute over whether a progress payment should be paid. So these are things that all are thoughts and issues that need to be addressed in those contracts. Who's responsible for the sales tax? We see a lot of contracts that don't specifically address sales tax. You get a contract and it's for $25,000, and then you get your first invoice or an invoice for the entire amount, and all of a sudden there's a few $1,000s more in there because they didn't include sales tax. So that's something obviously you want to have up front. In our master services agreement, I always put this is the contract price, and then it either includes or does not include sales tax. So there's no surprises for the association when you start receiving invoices for the contract or you receive the invoice for the contract. Another important provision is always indemnification. So if you hire someone to do work and they do something that causes damage to someone else, you obviously want them to pay for that damage. And it may be that they one of their workers comes in or and gets in a car accident or injures someone, and the person that's injured that suffered the damages says, well, I'm going to sue that contractor and I'm going to sue the association too. So indemnification comes into play, where in the contract you say, if the association is sued as a result of anything you do, you have to pay for it. You have to pay for our defense. And that needs to be very clear, very specific. And indemnification language is something that's very difficult to write. There's lawsuits about it. There's no perfect indemnification paragraph, but we think that our language is good language. And basically what that does is protect the association in the event the contractor or the vendor does something that gets the association sued. And another important part of indemnification is insurance. So a lot of you may have for example, a clubhouse that you rent out, and in your rental agreement, it may have indemnification language that says, if somebody gets hurt at your party in our clubhouse and they sue us, you have to indemnify us. You have to pay for that. Well, that's fine language to be in there, but in reality, the person that signs it, the person that rented the clubhouse, probably doesn't have the money to indemnify the association. Vendors are a little bit different, and they have the money, and the way that we make sure they have the money is that they have insurance. So the insurance funds the indemnity clause. And that's one thing that we look at with our MSA. Anytime an association sends me a contract, before I even look at it, I respond to the manager or whoever sent it to me and says, send me a copy of their certificate of insurance, because I want to look at their insurance first. That's what we're looking for: indemnity language and insurance to pay for that indemnity language. If they don't have enough insurance, how are they going to pay that indemnity clause, and what assets do they have? Typically you really want it to be funded by insurance. You want to see that insurance and have that language in your contract. It's a lot of vendors will say, I've got insurance and here's my proof of it, and then they present your contract. And one of the only way really that their insurance can cover the association, and you'll see this when they provide their insurance coverage sometimes, it'll say, we have this insurance and there can be a party that's named as an additional insured if it is required by a written contract. And most vendor contracts we see may say that they have insurance, or the vendor produces their proof of insurance, but nowhere in that contract does it say that the association is an additional insured. And if not, that insurance coverage means nothing. You've got to have that requirement, because I don't know if I've seen any vendor liability policies that don't require that the contract say whoever the additional insured is. So again, insurance is something that is very difficult sometimes to understand. I am not an insurance expert. I know enough to be able to look at a certificate of insurance. I know a little bit about what we think a vendor should carry in insurance. And, I mentioned before that you use your professional team. When I have a question, I find out who sold the association its insurance, and I contact them, and I'll ask them, this is what they're showing us. What does this mean? Is this insurance what we're looking for? And I consult with them to get help if I have a question on something. And that's all part of using all of the people out there that's available to the association to make the best decision for the association. So really, when we're looking at insurance, we want an admitted carrier. And what an admitted carrier means is that carrier has been licensed by the state to sell insurance. There are non-admitted carriers, and they can sell insurance in the state. But with the admitted carriers, you've got recourse that you can go through the Texas Department of Insurance if there's an issue with your insurer, and they will assist, sometimes contact the insurer to try to work out, the insurance company to try to work out whatever that issue is. There's some best ratings out there, and S&P ratings. These are services that rate insurance companies. We typically include a requirement in our master services agreement that they have a certain rating. Like Best Ratings has A++ and they have a letter system. Just like your grades in school, with A++ being the best or the most highest rated insurance company according to what their criteria are, and it goes all the way down to D and F. Insurance limits, that's another thing that can be very tricky. For a pool company, for a security company, we want the most insurance that we can get. We want them to have a general liability policy and umbrella or excess coverage policy, because those are the types of vendors where there is a larger risk of exposure. The problem we're having now, or the problem that associations are having, and I'm sure some of you have seen this, is that excess coverage liability, umbrella liability, has become very, very expensive. And it's been priced out of the range for a lot of companies. And so some of them are just making a decision, we are not going to carry it, or we're not going to carry what we used to carry. And, that's the deal. If you want to use us, this is what it is. And again, you've got to try to do the best you can. And you also have to make sure then that the association's insurance is up to date and that the association is fully covered. Because even if in a case where it's the vendor's fault, the association and the vendor get sued, the vendor's insurance is not enough, that's when the association's insurance is going to kick in and cover some of that. So you always want to make sure that the association's insurance is up to date and you've got sufficient coverage, which is a question for your insurance provider to make sure that you've got those things covered. Claims made versus occurrence policies, that will dictate what insurance company covers you. Is it when the claim is made, the insurance in place then, or is it when the incident happens? So you have to understand depleting policy limits too. And I mentioned before certificate of insurance, and this is going to kind of help explain some of that. This is typically what a certificate of liability insurance looks like. And this is just the top portion of that document. We're going to kind of go through the body of this document too. And what you're looking for is the name of the insured under producer. On the box that says insured, that should be the vendor's name. So if you sign a contract with Roadrunner Fence Company and they say, here's our insurance, and you look at this document under insured and it says Texas Fence Company, that is not your vendor. That is something else, and that's not their insurance. So you always want to make sure when you are signing a contract that the insured's name as listed in the certificate of insurance is the exact same name as listed in your contract. And this is kind of the body of the contract that lays out the coverages. And again, this is all part of a certificate of insurance. It's typically a one-page document. Sometimes it might be a couple pages if there's some writers that they need to explain on additional pages. But this kind of lays out the most typical forms of insurance we see: a commercial general liability, automobile liability, umbrella liability, and workers' compensation. And what you're looking for is that there's an X in each of those. And then over to the right, on the far right, you'll see where it says limits. And that's the limits of their coverage. And for commercial general liability, if you look at that, this company has it. And if you look to the right, it's each occurrence under limits. Each occurrence is $1 million. And general aggregate is $2 million. So what that means is they have enough general liability to cover two $1 million claims. And this is a typical policy, $1 million for each occurrence, $2 million in general on the general aggregate. So if your association gets sued, and let's say that's all the insurance they had, they don't have $2 million of insurance. They have $1 million for the occurrence that happened to your association. And then automobile liability, typically you want them to have $1 million in automobile liability. This is a commercial automobile liability policy. And you'll get some vendors who are small vendors, and they'll say, well, we have auto insurance. It's their personal auto insurance. And the issue with that is, well, that's fine. It's going to be much less coverage on that. But the issue is if the association were to be sued because they got in a car accident or ran someone over, their personal auto coverage is not going to cover the association. But if they have commercial auto liability, that will cover the association. And obviously there's issues of what's excluded, but that's kind of the main difference, is that commercial auto liability protects the association and may provide a coverage, where personal liability, personal automobile insurance will not provide that coverage to the association. And then you see in D, it's umbrella liability, and here they have the excess liability box marked. And if you look over to the right, they've got $2 million for each occurrence and $2 million in the aggregate. So really what this means is if there's an incident by the vendor, the association gets sued. Like I said before, you've got $1 million of commercial general liability up at the top. And then on top of that, there's $2 million in umbrella and excess liability in this case. So the total insurance available for that incident is $3 million to the association. And that's typically going to cover most claims. And then there's workers' compensation insurance on here, and there's $1 million, and that's, again, the typical coverage, and I think that's the limit of the coverage you can get in Texas. And one thing to point out, though, is, as I mentioned before, there's a general aggregate under commercial liability, and the aggregate coverage under umbrella excess liability is $2 million. And what that aggregate means is that it is possible that if your vendor, let's say they're doing work in 10 associations, and in 2 other associations there's claims, and in both of those they're max claims. So they've got 2 commercial liability claims in 2 other associations for $1 million apiece. And in each of those claims, their excess carrier paid $1 million apiece on each of those claims, because they've got $2 million in the aggregate and excess liability. So if that has happened, what that means is they are out of insurance. They have used up their insurance. And so that's something also to be watchful for, is to see what they have in the aggregate. There's a way that they can have insurance for each association. But again, I don't want to get too far in the weeds on this, and I hope I haven't confused you already. But it's really important, again, the point, I guess, is that your attorney or your insurance professional needs to look at every vendor's insurance and make a decision on is that sufficient? And to advise you, if this were to happen, you may not be covered, or there may not be enough insurance. So just keep that in mind, that what you're looking for in any vendor is that they have all of these coverages: general liability, automobile liability, umbrella or excess liability, and workers' compensation. And then I mentioned before, the association wants to be named an additional insured. So on the certificate of insurance, if you look at the bottom, it tells you general liability, blanket additional insured form, waivers of subrogation, blanket waiver of subrogation, and it tells you to which of these coverages it applies. We want it to apply to all of them because both of those things protect the association. Another thing you want to look at on the certificate of insurance, and this is at the bottom, is the certificate holder. In that box should be the name of the association, and it should be the legal name of the association as it appears on the association's articles of incorporation or certificate of formation. So we see a lot of these certificates come through, and the name of your association, maybe the Houston Homeowners Association, and down here in the certificate holder box, it'll say Houston HOA. Our recommendation is that it be the full legal name on the certificate of insurance. So that's a little primer on the certificates of insurance. Again, I hope it wasn't too much. And just the last comment I want to make on this last page is, if you look at the very bottom of this document, it says, when required by written contract signed by both parties prior to loss. And I mentioned that before, is that if your vendor, no matter how much insurance they have, if you don't have a written contract that says that the association must be named as an additional insured, that a waiver of subrogation is granted in favor of the association, if that's not in writing on a contract signed before the incident occurs, it doesn't matter how much insurance they have, because it's not going to cover the association. So it's very important that all vendor contracts have that language. And that's language, again, that we don't rely on the vendor document. We rely on our master services agreement, which is going to include that language. We've kind of gone over this in addition to kind of the main types of insurance, which is, again, liability, compensation, auto, and umbrella or excess coverage. There's different types of insurances that you may require your vendor to have: employer's liability, pollution insurance, which, if whatever their work is doing releases some types of pollutants, that'll cover that. Probably not something you need for most vendors. There's cybercrime and fidelity insurance. Fidelity insurance, covers things like dishonesty and theft. If your vendor's employees steal from you and they have fidelity insurance, that's probably going to be covered. There's a bullet point here: when a claim occurs, whose insurance pays first? Another piece of language we look for on that certificate of insurance is to make sure that it states that the vendor's insurance is primary and the association's insurance is non-contributory. And if you see here on the bottom of this form, a couple lines above the very last line, it says blanket primary and non-contributory form. So again, you want that language there. A lot of times the way that I write it is, on the certificate of insurance, I ask them to include a sentence: this insurance is primary to the association's insurance, and the association's insurance is non-contributory. So you want their insurance paying first. And again, it's about risk transfer that we've talked about. You're paying them to do a job. If something happens, then someone's damaged and there is a claim out there, they should be responsible for it. That's the indemnity language. And to be responsible for it means they need to be able to pay for it. That's the insurance language that pays those claims when they're responsible for something. And again, risk transfer, I mentioned, is something that's very important, especially something like pools and lifeguards. You want the risk to be held by that pool and lifeguard company or by that patrol company, not by the association. And the things we've talked about are the ways to do that: indemnity language, making sure they have sufficient insurance. There's been a lot of discussion about swim at your own risk, and even more now with the fact that a lot of pool companies cannot obtain sufficient insurance, especially sufficient umbrella or excess coverage. We are still generally recommending hiring these companies because they do have insurance and you're trying to transfer that risk. If you're doing swim at your own risk, it's the association that's on the hook for that. And you've got to try to protect yourself in other ways. And that's proper signage of making it clear that there are no lifeguards. You're swimming at your own risk. A lot of times people want to say, well, then we're only going to let adults do it. Well, that doesn't necessarily protect you, because some children are much better swimmers, or younger people are much better swimmers than adults. And if you try to exclude based on age, that could be a Fair Housing Violation Act. So there's all kind of issues that go into that. Obviously, if you have swim at your own risk, you don't want to have lifeguard chairs out there. You've got to take every step you can, and those are things you consult with your attorney about, to try to minimize what your risk is. Again, switching from lifeguards to swim at your own risk, we believe increases your exposure liability-wise. A lot of associations say, well, we'll just hire our own lifeguards. We believe that presents the most exposure to an association, and not only just in the fact that you can't transfer risk, but you bring up issues then like paying taxes for those employees, having to have workers' compensation insurance for those employees. An associations come to us a lot and say, well, we're going to hire this person and he's going to be a handyman, and we're going to say he's an independent contractor. Well, you can call someone an independent contractor, which is a way to try to reduce your liability, your exposure. But the fact of the matter is that if you're controlling the details of that person's job, if you're telling them how to do it, if you're providing the tools by which they do their job, they are probably not going to be found to be an independent contractor. They're going to be an employee, which again opens a lot of issues for an association on how that person has to be treated, taxes, insurance on that person in case they get injured on the job. So it's not as easy as saying, look, you're an independent contractor, we're not liable for anything. It just doesn't work that way. So you've got to be careful about that. And if you want to do that, you've got to make sure you talk to your attorney again to discuss ways to try to decrease your liability. And again, a third-party company is really the way to go. And this, we're kind of talking specifically about security. Same reasons: risk transfer that liability to that third party. A lot of people want armed patrols. We generally don't think they're recommended. If an armed guard shoots someone, everyone is going to get sued. There's probably not going to be enough insurance out there. It can be very risky, but we do know a lot of associations use them. And when they do, we're looking then for excess liability coverage in the $5 to $10 million range if you're using armed guards. And again, over the last few years, that has become so expensive. I don't even know if an insurance company offers $10 million in excess liability anymore. You want them to have the most insurance that they can have. And then also, like I mentioned earlier, you want to make sure that your insurance company is aware that you have these guards, and that if there is a claim, that your insurance is going to kick in if there's not enough coverage of the vendor. And that's a conversation you need to have with your insurance company. One of the issues with this insurance requirements is that it really can kill the kind of mom and pop vendor, the person that comes in with a photo booth and they bring it in their personal car and they set it up. And in reality, there's probably not a lot that may go wrong, but it could go wrong. And sometimes boards are surprised to find that, we really want them to have the same insurance as a larger vendor, maybe not in the amounts of coverage, but we still want that mom and pop to have $1 million in general liability, at least $1 million in umbrella, to have commercial automobile liability insurance, to have workers' compensation. So a lot of times that can kind of rule out these small mom and pop type vendors, but it's just that the exposure for an association, the risk is not worth the reward on a lot of those types of vendors. If you can hire a constable or sheriff's office directly, that is recommended from a risk management and risk transfer perspective. Even when those types of licensed law enforcements are working on private contracts, they generally have all the immunity and the coverage they have as if they were on duty with their constable's office. They've got some governmental immunity compared to, a private security company. The problem with them, obviously, is that they are expensive. There's really not much wiggle room in their contract prices, and there's not much wiggle room in their contracts. Typically, that's a document that's going to be provided by the county or maybe a city governmental entity, and they're not going to let you manipulate that contract too much. They're going to say, this is it. If you want to use constables, this is what you have to sign. But it is beneficial from a risk management and risk transfer perspective. So we've kind of gone through this. You can ask questions using the chat function. If you've got questions, I'm going to try to answer as many of those as I can. And just, the things to keep in mind with vendors is that it begins with a good understanding of the agreement and what you expect from them. And that can be done in the contract, in the scope of work. It should be as detailed as possible so that both parties agree on what each party is expecting from this. And I see that a lot, is that the scope of work comes and says, we're going to charge you $15,000 to build this fence, and we're going to build a fence that's 6 feet high. Well, that's probably not enough detail. You want in there how it's going to be constructed, maybe a rendering of what it's going to look like. We've seen contracts for $1 million contracts that are a page long, and I can tell you that is not going to cover all the things that it needs to cover. If you can establish and create a request for proposal, that's always a good thing to get out to vendors, and the RFP can have things on it like, these are our insurance requirements. This is what we're expecting. I know that it can be difficult to produce those documents and get them out there, but I'm sure a lot of you have boards with retired engineers on them, and that's the kind of things they love to do. Sometimes they may go a little too far, but a request for proposal, an RFP, is always something good so that all vendors are seeing exactly what you want, exactly what is required of them in terms of insurance, and they are all submitting a bid on the same criteria, hopefully. Again, we recommend the use of a master service agreement, and it's not really a form contract. It's more of a template that we begin with and then tailor it to whatever that specific vendor is. And we try to cover all the big three provisions, which to me is termination, indemnity, and insurance, but also address the things like the use of subcontractors, choice of law, like if there's a dispute, if your company's from out of state, they could put you in federal court. Well, our master services agreement says if there's a dispute and you're in Harris County, it's going to be in a state, Harris County State District Court. You want to control all of those things that you can. And then, of course, as with any contract, both sides need to perform as they have agreed to perform. And that's where the issue is. That's where it takes a lot of board oversight, a lot of management company oversight, excuse me, to make sure that, your landscaper is doing what they're supposed to do. I am sure you have all been in a meeting where the owners come and say that the landscaping is not being done correctly and who's watching them. And, it's like with any contract. Once you sign it, you can't just think it's going to happen. You've got to monitor that and make sure that the vendor is doing their job and have a process in place if you need to contact that vendor of how that's going to happen, who's going to do it. And, just make sure that you're getting what you pay for. I think that's all I have with the presentation. I would love to answer some questions. I don't know that I see. Oh, here we go.
Yeah, they're in the, got them in some in the chat, Cliff.
Found them in the chat.
Yes, sir.
Okay. Let me see if I can control that a little bit. All right, let me move this over where it's in front of me. Well, actually, let's not do that. Are master service agreements only for master associations, or can they be formatted to a standard size or individual PSA? Yes, that name, master service agreement, has nothing to do with a master association. We use these for all associations, big and small. If the board member who signed the contract is no longer on the board, does that mean that the contract is null and void? Should a new contract be drawn up and signed by a current board member? That's not necessary. When a board member signs a contract, I'm assuming that the board has approved that contract, and or at least the majority of the board has. And what that means is that's an act of the association. So that's a binding contract on the association, even if the board member that signed it has resigned or moved or is no longer on the board, the contract is still good. If HOAs are nonprofit organizations, aren't they exempt from paying sales tax in Texas? No, there's a a process you can go through to become sales tax exempt, and it's something that you need to talk to your accountant about to see if it's something that's really worth it for an association. I mean, if you're in a small association and you don't really pay much sales tax, probably not worth it for you to go through that process. Got some more here. Looks like somebody answered some of the questions. Should the MSE define in detail how the vendor's performance will be managed? Talking about the frequency of formal reviews, who perform those reviews, required feedback to vendor. You know, the more detail that's in your contract or your master services agreement that lays out the expectations of the parties and how things like that will be done, the better. So, you know, it's obviously you can't have every single detail in there because it could go on and on forever. But I think it's a good idea that it address all of those things of you know, who's going to watch over that, who's going to contact you. You know, vendors complain a lot that they're hearing from 3 or 4 different board members, and each board member is telling them something different, and the manager's telling them something different too. You know, and the manager's trying to act what they believe they've been instructed, you know, how they believe they've been instructed to act. So it's a good idea that if you find yourself in that situation, and maybe before that situation arises, to make sure that the board has an agreement on who is authorized to talk to that vendor. So that might be something you can do by an email vote, or even in the open session, is appoint a board member to be the liaison along with the manager, you know, to the landscaping vendor and to the pool company vendor. And it may be the same person, it may be different. And then you tell that vendor, this is the person who you take instruction from, or these are the people, the manager and, you know, the board vice president. And then when another board member contacts them, they can say, you know, I've only been instructed that I can take instruction or how to do the job or what needs to be done from the vice president. Could you please speak to that person and have them call me? And that way you avoid board members kind of going rogue or confusion amongst the vendor of who they're supposed to be listening to. So what if it is in the name of the management company? And I'm not sure what that question is, but I'm guessing that they're asking if the contract is in the name of the management company with the vendor. I mean, there may be some exceptions, but typically that should not be the case. Every association contract should be in the name of the association with the vendor. And again, I can't think of one now, but there likely are some exceptions to that. But I generally don't know that if I've dealt with one in the last number of years where the vendor's contract is with the management company and not with the association. Could you please say again what the bottom of the insurance COI should say? The language I use is This insurance is primary to any insurance obtained by the association name, and the association's insurance is non-contributory. If a community is paying for on-site staff, including taxes and insurance, does the association need to report their staff as employees? Wouldn't this mean that they are paying twice for the same coverage and taxes? That's probably a little too specific for me to answer. What I typically see is that we have associations and they may hire a management company, and the association may already have an on-site person for them. Typically, what I see is that person becomes the employee of the management company. And that's so the association can avoid all those employee related issues, and it's all handled through the management company. But I think the question you're asking is probably something you need to talk specifically to the association's accountant about. How detrimental to an HOA is it to accept insurance waivers to small companies and individuals who do minimal jobs? Well, that depends on the incident that occurs with that vendor, which, again, most cases, there's probably never going to be an issue. But when there is an issue, it can be a big issue. I mean, the person that brings in the photo booth in their car can run someone over the same as your landscaping company can, and cause just as much damage to that person. So, as an attorney, we're looking at what is your exposure to liability, and waiving insurance requirements means that you have exposure, and we want to recommend that you don't have exposure or you limit yourself. So just keep in mind that a small vendor can cause just as much damage as a large vendor. Do you have a template? Yes, we start with a template, but that's not something that we provide. We tailor it to the specific vendor agreement. When we're asked to by a client, they send us that agreement. Oh, the question was regarding additional insured. So it should only be in name of the association, not the management company, correct? Well, when I get sent a contract and an insurance, my client is the association. So my advice is that the association be named an additional insured. Now, in most cases, the management company is an agent of the association. So really what that means is the act of the management company is an act of the association. And again, in most cases, that insurance will extend to the management company. But that's kind of a general statement, and sometimes the specifics can be a little more complicated. But generally, the management company is an agent of the association, and any insurance covering the association will extend to the management company. If the vendor provides services to several associations, can the certificate be under the name of the management company? Well, it can, but if the certificate is under the name of the management company, that means it's not in the association's name, and the association is not going to be able to take advantage of being an additional insured on that policy. Andre, I don't see that there's any more. What time are we? 12:19. We've got a few more minutes if anyone wants to type in anything. This presentation will, at some point, probably in the near future, be available on our website, which is rmwh.com. There's numerous other educational newsletters and webinars on there if anybody wants to go on a number of subjects that affect associations. So I invite anyone to go on there at any time and see what's there and see if there's anything out there that can help you. Let's see. I think that you got one more.
One more just came in. Or a couple more.
All right. Let's see. Is the insurance agency that is used to obtain insurance also considered a vendor? Well, I mean, that's true. Obviously, they're selling something, but they're a little different, and there are some vendors that are a little different. Your attorney, your insurance company. I don't know that this really applies to those types of what are technically vendors. Previously, you had a similar program on PDFs. Is that available to view now? You may be talking about, I believe there was a Contracts 101 that should be on the rmwbh.com website. If not, you can contact us and we can and see where that is and get it on there if it's not. Can you please repeat what you said about waiving insurance requirements for vendors? I mean, I generally don't waive insurance requirements for vendors. Again, the smallest vendor can cause as much damage as a large vendor, depending on what they're doing and what the incident is. And anytime you're waiving insurance requirements, you're putting the association in a position of exposure and liability. I think that's all. I thank everybody for saying thank you. I think that's it.
Yes, sir. Looks like we're good to go.
Well, we want to thank everybody for coming. Again, we do these once or twice a month. And if you are not on our list, if you found out about this through someone else, we do have a list that when we send the invitations to these out to anybody that signs up for it. So thank everybody for being here. Bye-bye.